Assalamualaikum warahmatullahi wabarakatuh. I am IRFAN ARDIANSYAH from PERSADA Bunda School of Law. I would like to present my research, the title, Legal Protection of Intellectual Property Rights Toward Traditional Culture in Indonesia. First, introduction. Background of the problem. The people of Indonesia, intellectual property, especially traditional songs, is one of the common heritage, especially for Indonesian people who are communal and always carry the value of togetherness. Therefore, the Indonesian government protects traditional songs as expression of traditional culture by enacting Law Number 28 of 2014 concerning copyright. In these regulations, traditional songs and modern songs have difference in the process of recognition and protection. Traditional songs are included in category of traditional cultural expressions, which are a form of traditional intellectual property that has cultural value as a form of cultural heritage that is continuously developing in society. Formulation of the problem. What is the form of legal protection of intellectual property rights against traditional culture in Indonesia based on Law Number 28 of 2014 concerning copyright? The purpose of research. The purpose of writing this scientific journal is to better understand the concept of intellectual property rights and to know the legal protection of traditional culture in Indonesia based on Law Number 28 of 2014 concerning copyright. About discussion. Number 1, research methods. A, type of research. The type of research used in this paper is normative legal research. B, the type of approach. The type of approach used in this paper is a law or statute approach. C, the legal materials. Primary legal materials, secondary legal materials, tertiary legal materials. D, legal materials collection techniques. This paper that uses normative legal research has a technique of collecting legal materials in the form of library research on legal materials obtained. E, legal materials processing techniques. In terms of processing normative legal materials, library materials are used as research source. Of course, this includes stages such as formulating the legal basis, formulating legal understanding, establishing legal standards, formulating legal rules. And then I want to explain about result and analysis. Legal protection towards traditional culture based on Law Number 28 of 2014 concerning copyright. Protection of traditional culture in Indonesia is included in category of copyright. This is because the existence of traditional culture is in the realm of arts, literature, and science. The purpose of copyright is to reward the creator. The precise regulation of traditional culture in Law Number 28 of 2014 was Law Number 19 of 2002, or copyright law, especially in Article 10 concerning the control of traditional culture, copyright by the state for work whose creators are not known. Then, in Article 31, Paragraph 1, letter A, which regulates the period of protection of traditional culture, it is stated that there is no time limit. Traditional culture in Indonesia is protected by the copyright law as stipulated in Article 38, namely 1. Copyright for traditional culture expression are held by state. Number 2, the state is obliged to make an inventory, maintain traditional culture as referred to in paragraph 1. Number 3, the use of traditional cultural expression as referred to in paragraph 1 must pay attention to the values that live in the community that bears it. Number 4, further provision regarding copyright held by state on traditional cultural expression as referred to in paragraph 1 shall be regulated by government regulation. Nationally in Indonesia, related to traditional culture is regulated in Law Number 28 of 2014 concerning copyright. In general, legal protection for copyright works by creator is obtained automatically, which means without going through the registration process, first and the creator automatically has received legal protection for his copyright work when the work has been realized in the form of a real copyright work. Indonesia is one of the countries that regulated the protection of traditional cultural copyright under the scope of the Copyright Act. Basically, traditional culture is not properly protected under the scope of the Copyright Act. So it can be said that copyright law is not sufficient to provide protection for traditional culture. Protection of traditional cultural expression in Indonesia aims to prevent commercialization and action to damage or commercial use without the permission of the state as copyright holder. This is also specifically to prevent foreign parties from claiming or commercializing Indonesian traditional culture. Because the copyright law in Article 38 to 42 has provided protection in the form of prohibiting foreign parties or non-Indonesian citizens to announce or reproduce the creation of cultural expression. In my research, I have conclusion and suggestion. About conclusion, the form of legal protection for Indonesia culture in Indonesia based on Law Number 28 of 2014 has provided legal protection in the form of prohibition on foreign parties or non-Indonesia citizens to announce or reproduce traditional culture creation from Indonesian cultural products. And about a suggestion, the government's efforts in providing legal protection for traditional cultural expression still need to be improved by adjusting the preparation of laws and regulation related to the time period. That's all I want to presentation. Thank you. Wabillahi taufiq wa hidayah. Wassalamualaikum warahmatullahi wabarakatuh.